All right, we're going to continue our conversation on public relations and the law. This is based on the textbook Public Relations Strategies and Tactics, Wilcox and Cameron, 10th edition. I hope you have a copy of it. Trademark law. And we've already been talking a little bit about trademark and the difference between copyright and trademark. A trademark is a word, a symbol, or a slogan that identifies a product's origin, or in other words, it identifies its owner. And a licensing fee must be paid before anyone can use it. So here's a video on trademark law.
Copyright, trademark, and patent are the three main components of the intellectual property law. Patent protects inventions, as it gives the inventor a monopoly on the manufacture, use, or sale of his innovation, while copyright protects creative works, such as writing, visual art, music and audio recordings, from unauthorized reproduction. While trade dress is the look and feel of a product, its shape, packaging, and design that signify the source of the product to consumers. On the other hand, trademarks are brand names, which are labeled to products and services. The mark is a distinguished sign, like a word, phrase, symbol, or a combination of these elements. A mark is used in business to indicate the source of the brand, in order to distinguish and identify it in the market. Trademark protects the customers by preventing the public confusion as to the origin or quality of a product, in addition to rewarding the brand owner by maintaining his business' successful reputation. Unlike most countries, the American law protects a brand, even if it's not registered, which is known as the common law trademark rights. As the trademark ownership belongs to the first seller, who use and trade the brand in the market. A trademark infringement could happen when a likelihood of confusion exists between trademarks, which means that the brands are very similar, that consumers would mistakenly believe the two products come from the same source. In this case, the fake brand has to stop misleading the market, and is liable to pay damages to the original brand owner. However, trademark protection is not absolute, as it's subject to certain limits, such as the trademark abandonment, geographic limitation, and the fair use of the brand by a third party.
All right, so there's a good overview of trademark law, and a little bit again on copyright. So Coca-Cola is certainly a very well-known trademark. In fact, probably the world's most recognized trademark. Logos are trademark. Indeed, that script representation of Coca-Cola is a logo. The Dallas Cowboy star is a logo. So you cannot use Cowboy star, just take that symbol that is so well known and use it for your own profit. Organizations insist on the proper use of their trademarks in order to prevent them from becoming generic through general public use. Now, this has happened. Trade names that have become generic: aspirin, thermos, cornflakes, nylon, cellophane, yo-yo. All of these were originally trade names and have become generic so that anyone can use them, and we want to prevent that from happening. Public relations practitioners play an important role in protecting the trademarks of their clients. And here are some things that PR professionals do. They ensure that company trademarks are capitalized and used properly in all organizational literature and graphics, because lax supervision can result in the loss of trademark protection. What difference does it make if it's capitalized or not? It's the difference between a proper name and not a proper name. So thermos would be capitalized. Nylon would be capitalized, cellophane, yo-yo, and so on. And if it's not capitalized, then it's more of a general use word. PR professionals will educate employees as to what the organization's trademarks are and how to use them correctly. They monitor the mass media to make certain that trademarks are used correctly by others. Check publications to ensure that other organizations are not infringing on a registered trademark. And then continuing, PR personnel make sure the trademark is actually being used. An organization may not hold a name in reserve, so if it is not used for a long time, it can be lost. They ensure that trademarks of other organizations are correctly used and properly noted. Again, we're talking here about things that you as a public relations professional early in your career, as a beginning level employee, entry-level employee, or mid-level employees, things that you might come in contact with. PR practitioners avoid the use of trademark symbols or cartoon figures in promotional materials without the explicit permission of the owner. Right? So again, we cannot just use, in particular, cartoon figures. You see this quite a lot. That doesn't mean that it's okay. Mickey Mouse, Snoopy, so on. You cannot just stick those into your design without permission. Misappropriation of personality, this is very similar. It is unauthorized use of well-known entertainers, professional athletes, and public figures. For example, Elvis Presley, Marilyn Monroe, Michael Jackson. Even though these are folks who have been dead for some time, their estates still control the use of their name and likeness. And you cannot use the name, of course. If you're writing about Marilyn Monroe, you can use her name, but you cannot use her image without permission. Deceased celebrities are protected. Elvis, Marilyn Monroe, Michael Jackson. Elvis's estate generates about $40 million annually from his likeness. Regulations by government agencies. Advertising and product publicity receive less First Amendment protection than other forms of communication. We've talked about this once before. They fall under the category of commercial speech. So there is First Amendment protection, but it is less than a general article in a newspaper, for example, would receive. Commercial speech may be regulated by the government in the interest of public health, safety, and consumer protection. So the Federal Trade Commission comes into play here. The FTC has jurisdiction to determine that advertisements, product news releases, which would fall under the category of PR, and promotional videos and brochures are not deceptive or misleading. So the Federal Trade Commission is not only concerned with advertising, but also with public relations materials, which are promotional. This is a nice summary of what the FTC does with respect to advertising and public relations. What truth in advertising rules apply to advertisers? Advertising must be truthful and non-deceptive. Advertisers must have evidence to back up their claims. Advertisements cannot be unfair. So again, we think mostly of this having to do with advertising, but it can also apply to public relations. And I'm scrolling down here a bit. What penalties can be imposed against a company that runs a false or deceptive ad? And you see cease and desist orders, paying a fine of $43,000 per day if the company violates the law in the future. So you would receive a cease and desist order if you did not stop and you continued to use the deceptive advertising or presumably public relation material, then you might be subject to a fine of up to $43,000 per day. So a lot of information there. It's a very useful publication. The FTC, in fact, fined Facebook $5 billion recently. So this was very widely publicized situation. If you have ever wondered what a paradigm shift looks like, You're witnessing one today. The FTC's $5 billion civil penalty against Facebook for violations of an earlier FTC order is record-breaking and history-making. In addition, the settlement requires Facebook to implement changes to its privacy practices. This goes on to say that this had to do with the FTC as far back as 2012, charging Facebook with 8 separate privacy-related violations, including that the company made deceptive claims about consumers' ability to control the privacy of their personal data. And we were talking about privacy concerns here in the previous outline, invasion of privacy. So this is an example of that. Here's a video on a misleading ad that the FTC took action against.
Flatter stomach, younger looking skin.
Sign me up.
Right? It's what the ads promise, and they promise it for free, and it sounds so good.
Yeah, a little too good to be true, possibly. Well, tonight, the Let Joe Know team continues to look at how misleading advertising is costing consumers a lot of money.
Try it before you buy it. Pay for shipping, don't like it, send it back, no more charges. Great if it worked that way. Joe Ducey and Courtney Holmes here.
We showed you how 2 Valley call center operators say companies sometimes charge customers even if they return the product.
The Federal Trade Commission says some free trial offers could be designed to take your money.
We've even brought cases where you could return the product after 10 days if it was unopened, but you don't even get the product until after the 10 days has already passed.
The FTC's Kerry O'Brien says last year $20 million in refunds went to customers of One Technologies, which they say offered free credit scores but still billed people monthly.
And if you do order a free trial, know the length of the return, when it begins, and what you have to do.
Yeah, and if you still have a problem, don't let the company tell you it's something you should have seen online.
The company always has that excuse, it was in the terms and conditions, but if consumers don't see it, it's not good enough.
Check out our free trial stories at abc15.com. Click on sections and let Joe know.
So very interesting video there about misleading advertising being policed by the Federal Trade Commission. And again, the FTC is also concerned with public relations materials. Following general guidelines adapted from FTC Federal Trade Commission regulations should be taken into account when writing product publicity materials. Well, here we're talking about PR materials. Make sure the information is accurate and can be substantiated, that it can be proven. Stick to the facts. Don't hype the product or service by using flowery, non-specific adjectives and ambiguous claims. Make sure celebrities or others who endorse the product actually use the product. Don't say anything about the product, again, that can't be substantiated. Don't say independent research study when the research was done, in fact, by the organization's staff. It's simply not truthful. Provide proper context for statements and statistics attributed to government agencies. Government agencies do not endorse products, so don't make it appear that the government agency is endorsing the particular product. Describe tests and surveys in sufficient detail so that the consumer understands what was tested and under what conditions. So be not only truthful but clear in your explanation of tests and surveys. Remember that a product is not new if only the packaging has been changed or the product is more than 6 months old. When comparing products or services with competitors, make certain you can, again, substantiate your claims. Avoid misleading and deceptive product demonstrations. Now, we will finally wrap up here with some advice about working with lawyers who are employed by a company, and very often lawyers and public relations people are working on the same project or situation. And so they come in contact, and sometimes they may come in conflict. So these are steps to ensure that the public relations and legal staffs have a cordial and supportive relationship. The PR and legal staffs should report to the same top executive who can listen to both sides. So they should be under the control of and the direction of the same person or the same office within the organization. PR personnel should know basic legal concepts and regulatory guidelines, which is what we're attempting to convey right now. Both functions should be represented on key committees. So legal concerns and public relations issues should both be represented when committees are meeting and making decisions. The organization should have a clearly defined statement of responsibilities for each staff, and neither should dominate. They should each have equal say-so in the operations of the company. But also it should be clear what each one, legal and PR, what each one does. Periodic consultation should be held in which materials and programs are reviewed, so there should be ongoing communication between PR and legal personnel. And the legal staff should brief public relations personnel on impending developments in litigation so that press inquiries can be answered in an appropriate manner. So the legal staff should keep the public relations folks informed. So if the media contacts the PR organization, then we understand what's going on. We have received some background and we can respond appropriately. All right, so that is the end of our conversation here on public relations and legal issues. And as I say, there's a lot here that we have left out, just trying to keep it as concise as possible. But I hope this is helpful, and we'll move on to another subject next time. So thanks.